My name is Yaakov Singer, and I'm a student in the St. John JD LLM program. In the KRO case that followed Pondgate 2 years afterwards, there was a 94% write-down. Would you have reached the same result as you did in Pondgate, where the write-down was only 17%? Or would a 94% write-down be considered inequitable?
You mean to say that the RKO, I'm not familiar with that KRO case, but the value of the property was 94% less than the amount of the mortgage?
Right.
Okay. Well, I think the answer to that is that you follow the statute. And the statute says that the claim of the creditor is entitled to the value of the collateral, or the value of the property. And if the value of the property is minuscule, then that would be the return under this Chapter 12 Act that the creditor was entitled to. Now, Chapter 12 was really evolved from something historically, the Frazier-Lemke Act, which was enacted about 1934, I believe, by Congress in answer to the farm crisis in this country. The 1928 and 1929 stock market crash is the general origin of the so-called Great Depression. Actually, we must have been in a depression a little before that, because there were a lot of foreclosures in the United States in 28. 2,000 or 3,000 banks went under. My daddy's bank in a little old dinky town in North Georgia went under in 28 among 2,000. But in 29, we had the stock market crash of October. And then the repercussions of the economy was worse, far worse, than what we're going on now in the United States, banks and so forth. But farms, a lot of farms around the United States had loans where the value of the farm property was $100 an acre. But all of a sudden in 1931 and 2 and 3, it was $5 an acre. I mean, you couldn't even sell land. And so my daddy used to say that if it hadn't had the Frazier-Lemke Act, New York Life Insurance Company and Metropolitan Life Insurance Company and so forth would have owned all the farms in the country. Well, that's not exactly true. That's not exactly true. A lot of banks had mortgages on those banks, on those properties too. What Daddy meant was the creditors would have foreclosed on all of those properties. And despite what you think, and despite what some people talk about nowadays, banks really don't want that property back. I mean, they don't really know how. It's like the dog who caught the car. They don't know how to run a farm. They don't know how to run a General Motors. So the Frazier-Lemke Act was an act designed to save those farms into the ownership of the farmer. So the value of the property was now at $5, and the Frazier-Lemke Act allowed that. In studying the Frazier-Lemke Act and in studying the Chapter 12 Act, it's a good thing for you all to do, because the statute is virtually the same in that you could give the property back to the creditor. That satisfies the debt. Or you could sell the property on the open market. That will satisfy, and give the money to the creditor. That would satisfy the debt. But then the fourth provision would allow the court to appraise the property. And if you appraise it correctly, then that ought to be the real value of the property. And if the debtor can raise the money somehow and promised to pay that, I think is over a 3-year period, then that would be the value that the creditor bargained for when he made the original loan. And it's kind of like in Chapter 13, it used to be, it's not anymore. You go buy a car and you paid whatever, $20,000 for it. You drive it out in the street, it's not worth $20,000 anymore. It's now a used car. So a month later, 2 months later, and certainly 6 months later, it's going to be worth on the market a whole lot less. Okay? And it used to be that under Chapter 13, that the creditor was entitled to the value of the car. I think now you can't do that under the BAPCA, or whatever that law is called, 2005. The creditor is entitled to the amount of the loan. Well, under the Chapter 12 and under the Fraser-Lemke Act, the theory is that if you appraise it, that's the value. And you read some of those opinions of Fraser-Lemke Act and so forth, the Vinton Branch versus something, and the Wright versus something was the one that was declared constitutional. One of them was declared unconstitutional, and the other one, Congress went back, and in 67 days they remedied the criticism of the Supreme Court on the first act. And the Congress didn't do that with the Reform Act when it was declared unconstitutional. But in that act, they 67 days later, I think, they remedied it, and then the Supreme Court approved the act.
Now, we're going to talk about unconstitutionality.
Huh?
Well, Judge, could I just
Yeah,
add a footnote? Add a footnote.
by all means.
When your decision came down in Pinegate, the attorney for the bank from L.A. came into New York. He was so incensed. He came into New York, and he tried to get MetLife and primarily American Council of Life Insurance to join him in a petition from the bankruptcy court to the Supreme Court of the United States.
Direct.
Direct.
Yeah.
And we said, you can't do that. And he said, well, I found a writ of prohibition or writ of proscription, I think, an ancient writ that I could get, and I want to do it. We passed on that. But
Who were you working for then?
MetLife.
MetLife.
And
Well, MetLife had more sense than he did.
well, I had a copy of the petition he was going to submit, and I had mentioned that to you on the phone, and you said that you had gotten no word that they were planning to
No,
go
I never
from
heard
the
that. I never heard that
bankruptcy
story.
court.
Now,
So maybe they never submitted it. My files all went down with Two World Trade Center in
well,
in,
it's funny how much
September
consternation and how much talk resulted from the Pinegate case. When that was rendered, actually there were 4 opinions in that case, and when you ask some of these publishers for it, they send you the wrong one. But immediately after that decision was filed, and the lawyers around the country found out about it, that this, as some of them said, this Bolshevik down in Atlanta had rendered this opinion, and they called me everything under the sun. They couldn't, and by the way, most of the judges around the country thought that was bizarre for me to have ruled the way I did. Well, I ruled the way the statute said, and which I tried to do always. And but the mortgage company, mortgage lenders were incensed all over the United States, of course. But I was interested that I had a lot of comments around Business Week and Forbes and Wall Street Journal and so forth talking about that opinion. And I remember one quote was by a general counsel or something with some big bank, and he was quoted in Business Week as this: "Well, we always knew what Judge Norton ruled was the law, but we didn't think that any judge would ever have the guts to rule that way, because it's so contrary to the thinking of most mortgage lenders and most of the bench and bar." So apparently there were some people around the country that were afraid some judge someday would be unwise enough to rule that way.
Judge Norton, shifting your attention to bankruptcy court jurisdiction and with respect to the Supreme Court's Northern Pipeline decision, do you feel that the Chief Justice may have been biased against Article III status for bankruptcy judges, and how so?
I noticed you used the way "may be" biased, and I think the answer to that is that, with all due respect to the deceased, is that positively he was biased about a lot of things, and that actions of him post Northern Pipeline decision was terrible, really, for a member of the judiciary, let alone Chief Justice of the United States of America, to do some of the things that he did after that Northern Pipeline case is to me sordid and injudicious action. I refer you to the first edition of the Annual Survey of Bankruptcy Law, which Dick Lieb is now the editor and doing the best job we've ever had done for us. The first issue, 1979, my publisher, I told them that when I was agreed to write the treatise, that it was going to take me 2 or 3 years or more to write the treatise, but I got an idea that I'd like for you to do now. That is, we don't have a law review in the United States on bankruptcy law, and I'd like to start one. And so we called it the Annual Survey of Bankruptcy Law, which was sort of a takeoff on the Business Lawyer publication, which has annual review of business law. And so in that issue, I wanted to cover some legislative history of the Bankruptcy Reform Act. And one of the reasons was, when I was looking for laws, looking up the Fraser-Lemke Act and the Chapter 12 Act, I couldn't find any legislative history. There were hardly any references to Chapter 12, and not many on Chapter 10, which was almost identical as to those provisions we're talking about. And I was looking for that and couldn't find it. Plus, I couldn't find any really relevant commentary among lawyers and local law reviews and so forth about Chapter 12. So I thought that this Reform Act of 1978 ought to have a publication that tried to assemble a lot of the legislative history, that is, comments by the ones that were there at the creation. And so in that 1978 review of the law, I included some of these things about the Chief Justice. And we quote Senator DeConcini, said he got a call one Saturday night from the Chief Justice, and he, quote, yelled at me about this chapter, about the support that was in Congress for the Article III status of the bankruptcy court. So anyway, yes, you're right that he was more than a little biased.
Right.
Judge, the practice of bankruptcy law used to be frowned down upon by the rest of the legal profession. Today it's a little bit different. It's probably one of the more lucrative and embraced legal fields. Why and how do you think this change came about?
Well, You know, the Bankruptcy Reform Act of 1978 was a product of about 10 years of effort by the knowledgeable people in the bankruptcy field that we needed a substantial modernization of the bankruptcy laws, and that we were still traveling under a 1898 Act, which was passed in the horse and buggy days and had passed for automobiles, passed before many joint ventures, and certainly these modern organizations of businesses, and that we were traveling in modern days where we were putting the man on the moon, but we were functioning in the bankruptcy field under a law passed in 1898 in the horse and buggy days. So they spent, Congress, a couple of senators asked for a study, and they studied, they passed a law in, I think, 69, but it didn't last for about a year because they didn't realize you couldn't do all of this in a year. So they came back in the next year and passed the, I think, 1970 Commission on Bankruptcy Laws of the United States, and gave it authority to hire staff and to make studies and to conduct hearings and so forth, and they did. So that was a 3-year period, and then all that time the bankruptcy judges of the United States were talking about it, and the bar around the nation was talking about this bankruptcy commission. Bankruptcy commission had people going to hearings and going to conferences. We had the bankruptcy commission asking famous people like Countryman and so forth write papers. And so then in the early part of 1974, the Congress started dealing with it, and they had hearings, and they had, again, conferences, and they had staff. Fortunately, they had a good staff. And the whole decade of the involvement of the Bankruptcy Reform Act of 1978 had a lot of publicity. And the criticisms of, in Congress, of a lot of people about the bankruptcy ring and about incompetent, or pardon me, mediocrity referees in bankruptcy. They were appointed by district judges all over the United States, and some of them were, better than others. And you didn't have all Asa Herzogs in New York. You had some that weren't, couldn't even put on his robe. And so there was a lot of criticism of that. And all of this permeated, I think, to the bar and to maybe industry too, that when the act was finally passed in '78, that people realized that now we have an act that is better than ever. The appointment of the judges were different. Maybe the court would be better, or at least accepted better around the country. More status to the court. And despite what you think, the body of law, I think, relates a great deal to the status and acceptance and respect that the bar has for the court. And the respect of the court, I think, dribbles down to the respect of the law. And so I think that after the Reform Act, that a lot of lawyers around the country accepted the fact that bankruptcy court had big cases, had important cases, that the field of law was important. Whereas the previous to the 1970, a lot of the bar looked down and owned the practice of bankruptcy law.
My name is Jonathan Petz. I'm also a LLM student here. To turn our attention back to Northern Pipeline, what was the feeling among bankruptcy judges about their future and about the future of bankruptcy practice in the wake of that decision?
The Northern Pipeline decision declared unconstitutional the function of the bankruptcy court, that the court could not adjudicate and hear and try and issue final orders in certain types of cases, and that were considered, those kind of cases were considered the exercise of the judicial power of the United States, which is a phrase that's used in Article 3 of the Constitution. Article 3 of the Constitution says that any court or any judge that exercises the judicial power of the United States must be appointed under Article 3 for lifetime as tenure and protection from diminution of compensation.
Future.
The idea is what I'm trying to say. The idea of Article 3 bankruptcy court and the appointment by the President of the United States upon recommendation of the senators was anathema to a lot of bankruptcy judges. They didn't think I might not get appointed. And so really it was a job tenure expectation among a lot of bankruptcy judges. I don't want Article 3 because I won't get appointed. Now, Article 3 status in the court isn't about judges. It's about protection of the litigants, to give an independent judge to both sides or all sides of the issues. And if you don't have an independent judge that's not afraid of his job, then you might have some kind of bias. And so it wasn't really the idea of an Article 3 court was not well accepted by most of the, well, I shouldn't say most, but a lot of the bankruptcy judges around the country.
America is going through its worst financial crisis in nearly 30 years. Do you envision this leading to further substantial revisions in the bankruptcy code? Specifically, do you think that the unsuccessful attempts to allow Chapter 13 debtors to write down their principal home mortgage should be passed in the wake of this mortgage crisis?
Well, predicting the future is a difficult attempt, different assignment. I think as a result of the 205 legislation and the way that came about, probably is a negative toward the Congress getting back to that problem of bankruptcy. First place, Congress doesn't like to deal with the bankruptcy issues, the bankruptcy problem. And so despite the great trauma of the United States and creditor and debtors and the problems we're going through in this country, which really are unique. A lot of them were unique even to the Depression of the 30s. That I don't think Congress wants to touch bankruptcy again unless there's some tremendous movement by a lot of people toward a reform. I think some of the things that were enacted in the 205 legislation are actually hurting the recovery of some debtors now in the present situation. There's some articles in the latest issue of the American Bankruptcy Journal that deal with that. There's an announcement in the journal or announcement by ABI recently that there's going to be a conference very soon, I think it's in December, in Washington, D.C., concerning proposals for legislation. Actually, I don't know whether it's proposal for legislation or whether it's pointing out what's wrong with the present situation. But talking about what's wrong with the present situation is really a first step toward maybe moving toward legislation. I hope that there is a movement towards some modifications of certainly the 205 legislation. Let me make this statement right now too about in the decade that preceded the Bankruptcy Reform Act of 1978. One, you had a commission of competent, really, Professor Kennedy, Gerald Smith, and some others that they recruited to consider what's wrong with the present and what we could do to improve it. And hearing all these testimonies from everybody around the United States that was interested, hearing all of that and digesting that to come up with the Reform Act. They had a good staff, and they came up with a bill, and they came up with a report, a very thick report of why this section should be enacted and so forth. Then it went to Congress. And Congress, for once at least, attracted a very competent staff. The clerk of the House of Representatives Judiciary Committee, can't think of his name right now, but he is from California. And then Professor Kennedy, no, Professor Vern Countryman from Harvard recommended a couple of guys. One of them was a fellow named Richard Levin, and he was a minority counsel or majority counsel, and then Kenneth Clee, who a lot of you all have probably heard about. They were young fellows right out of school, and one went to Harvard and one went to Yale, and they were on the House committee. So the House committee was composed of a lot of very interested congressmen from the first place, people that were interested in bankruptcy and interested in reform, and were very smart people. Don Edwards and some others. And then they had a staff that was very good. So the whole thing was a professionalism type of effort. And I consider that method of enacting legislation, that is, study it first by non-Congress people, competent people, then Congress being competent, that is the legislators and the staff studying it very much. And that is the model of, to me, the way legislation ought to be enacted. But we normally don't do that. The 2005 legislation was just I don't even know whether they had many public hearings. If they did, they were people that were invited by the biased senators and congressmen. They want them to testify what I feel. Now, that's a terrible thing to say that's going to be published, but it's the truth that that legislation was the way legislation ought not to be enacted. There's been public statements by reputable folks that apparently know things that the 205 legislation was enacted at the instance by the credit card industry of the United States. And when I was when I was president of the American Bankruptcy Institute in '89 to '91, there was a committee of creditors, credit card people and others, that came to me and they showed me what they wanted, that they had about 13 or 15 things they wanted. That's the legislation they wanted. And I said, my God, if you got this, you're asking for the repeal of the Bankruptcy Act. not and in favor of creditors. You'll never get this, but they did. They got most everything that was in that list that they wanted, and showed me in 1989. And the statistic, the reports are there was more contributions from financial institutions to the Congress, to the judiciary committees of the House and the Senate, more than there were contributions to Congress in the legislation of 4 years ago on pharmacy, not pharmacy, but the health care. And more than the transportation bill of, I think, 3 or 4 years ago. And pharmaceutical, the pharmaceutical industry spent less in Congress than these credit card people did. So they got what they wanted. I hope that what's going to happen, if there's going to be any legislation, that it's done the way that it should be done, and not by some biased sort of group.
Judge Norton, my name is Nicholas McGrath. I'm a student here in the the LLM and bankruptcy program. What were the reasons that motivated you to participate in the formation of the American College of Bankruptcy? And in your opinion, were those goals achieved?
Well, it's going to be another long answer. Because during the enactment of the 1978 Act, we heard all these accusations against the present system and the favoritism and the maybe mediocrity of the court and the bankruptcy judges, and the two-step system of the referee doing something and then the district judge maybe have an appeal. District judges being able to appoint buddies to being referees. All of that went on during the 70s, and then the Bankruptcy Commission came into effect, and the Bankruptcy Commission said we got to give to this new bankruptcy court all this jurisdiction, and they said this jurisdiction is going to be massive, and it's going to be broader than any other court has in the United States, and which it is really. That it's got to have what kind of court should it have to adjudicate this type of jurisdiction? And so they pondered and asked a lot of questions around the country of constitutional lawyers, and they came up with it's got to be an Article III court. You can't adjudicate all of this type of jurisdiction without having a court that can exercise the judicial power of the United States under Article III. So they recommended a Article III court, and this was in the last year of the existence of the commission. But then that was announced of the nation, and all of a sudden, within 2 weeks, Chief Justice Berger called all the members of that committee. By the way, that committee was a very fine committee, the reformer. You look on those people and you see some real fine people and fine bankruptcy types. But they were all of them trying to do what's best for the United States of America. And Chief Justice Berger heard that and said, my God, make those referees Article III judges, we can't have that. So he called all of the committee, and the committee had a meeting immediately and withdrew it. There were congressmen and there were others on that committee that withdrew that recommendation. So then it went to Congress. And then Congress studied it in 74, 5, and 6, and then they talked about the jurisdiction, and they had some hearings before some people, and finally, one professor or some lawyer was testifying one time and said, this jurisdiction is wonderful, and that'll dispense the business of the bankruptcy court. Very good for a judge to be able to exercise all this jurisdiction, but what kind of judges are you going to have? What kind of court are you going to create for this? It seems to me that you can't have this jurisdiction under a bankruptcy judge without that bankruptcy judge being an Article III appointment by the president. So the House of Representatives Judiciary Committee said, well, let's do a study. And so they did a study that's about 200 pages long, and they asked 20 or 30 or 40 so-called constitutional lawyers around the United States and some others, professors all over the country, do you think this jurisdiction requires an Article III court? And the majority of them said, yes, of course. So the House of Representatives in H.R. 8200, I think it was, said we're going to have an Article III court. Well, again, Chief Justice didn't want the Article III court, and he started lobbying around. And they got into the House bill, went to the Senate, and the Senate started considering this, and the Senate was very much more moved by the Chief Justice and federal judges than by this need for this type of legislation. And they came up with a court very similar to the tax court of the United States, appointed by the president, but not a lifetime. I think 14 years term or something like that. So that's what they came up with. And then, but that from 1977 through the 78, there was a lot of attention around the United States and in Congress concerning about Article III.
Is that what
Also,
the ABI?
and so this concerned me because I wanted an Article III court. Whether I got appointed or not didn't make any difference to me. I practiced law before, and I can go practice law again, and I can make a decent living. So, but a lot of lawyers, I mean, a lot of judges didn't want to practice law. And so, but I said, I can, so I'll take my chances. And so the bankruptcy committee of the American Bar Association met in Chicago in about August of 1978, and when this issue was really, and they had a big debate, had 200 to 300 people in the room, and I think I was attending, and I know I was attending, and I think Dick Lee was attending, and the bankruptcy committee decided, yes, we want to recommend to the American Bar Association to get behind this proposal for Article III court for bankruptcy judges. And so that they recommended to the Board of Delegates, it has to go to the Board of Delegates of the ABA before anything can be recommended by American Bar Association. And so it went before that committee, and I called my two delegates from Georgia to the Board of Delegates and asked them about this. And they said, well, Bill, I don't know. I received half a dozen calls from Article III judges saying they're against it. And you're just a bankruptcy judge, and I don't know how long you're going to be, but they're going to be there for life. And I got to practice before them. So I can't support this resolution of the American Bar. So they had a meeting in Atlanta in September. Now remember that the act was passed in October 23rd or something like that. And so they had this meeting in Atlanta of the Board of Delegates of the American Bar Association. And I stood out in the hall. I think Dick Lee was there, and I think Gerald Smith was there. Came down to hear that. We couldn't hear, of course, they were in another room, but we could hear loud talking. It was in the big hotel, and Hyatt Regency, I think. And so they overwhelmingly rejected the recommendation of the Bankruptcy Committee of the American Bar Association. And so they were against. That probably had a lot to do with the Senate's decision to reject the proposal of Article 3. So I concluded from that, finally it was passed and so forth. I concluded from that the American Bar Association was never going to do anything constructive for bankruptcy legislation if it involved Article 3 or involved anything else that pitted the Article 3 judges in the United States against the others. That they were going to always go with the Article 3 judges if that's what the Article 3 judges wanted. And that we needed another organization in this country besides the American Bar Association. American Bar Association wasn't reflecting really what I think a large segment, maybe the majority of the American Bar members thought about. But the members of the Board of Delegates are people elected by the establishment of the local bars, really. That's the big firms and so forth. And they primarily practice where? In the district courts and the Court of Appeals, that is, before bankruptcy, for Article 3 judges. So I said we need something else. And so when we started with my treatise, my contributing editors heard me expound on that some. And we said, when we get through with this treatise, I want to form an organization in this country that's different from the American Bar, but composed of people interested in the bankruptcy field. Bankruptcy practice, bankruptcy, have everybody that's involved, lawyers, professors, others that are involved in the bankruptcy process. Have them as the members of this actually I didn't have a name for it, but this organization of people, an organization separate from the American Bar Association. So when all my people on the treatise knew about this, and we had discussions about it, they said, when are you going to do it? I said, well, I'm not going to do it as long as I'm a judge, and I'm not going to do it as long as we're writing this treatise. I'm going to finish this treatise first. And then after that, maybe we'll think about what we can do about forming what turned out to be American ABI. And along this same line, at the same time, I said, we need another organization. This will be a membership organization anybody can join, but we need another organization in this country that will be like the establishment bar, that is the American Trial Lawyers Association, there's one, American College of Trial Lawyers, and the American so forth of other lawyers. A friend of mine in Atlanta, two of them, formed the American College of Real Estate Lawyers, so I knew them, and I got their charter, and I said, when this treatise is over, I'm going to think about this. So the treatise was over, and I remember one person was very interested in this in my group, and he wanted me to start this organization. And but some of the people in the organization didn't really think we could ever put it over. Form this association separate from the bar, American Bar, and form this college. And so I looked around at my contributing editors as to who might head this thing, because I was going to be a judge for a while, and I didn't want to do it while I was a judge. I thought that'd be maybe improper, or considered by some people improper. So I didn't want to do it. So, but Dick Lieb was a busy lawyer. Gerald Smith's a big lawyer. But all the rest of my people were judges or big lawyers, and they couldn't do it. So finally we said, well, I'm not going to do it for a while. Then the Northern Pipeline case came by in June 28th of
82.
80, yeah, 80. So 82. So there was chaos in the country by then. Was this court, the Supreme Court gave a 90-day extension or stay. And then the Congress didn't act in that 90 days. And there was a lot of lobbying there too against the revision to make it Article 3. And so they extended it to another 90 days. During that time, Dick Lieb and I wrote an article that it couldn't be anything except an Article 3 court. That was the only thing they could do. Well, they could ignore and not do anything, which they did. And so I think we wrote 2 articles. And so, but a lot of judges around the country didn't think well about me writing articles supporting Article 3 when that was against the Chief Justice of the United States. That was against Article 3 judges all around. And so it wasn't really a popular move on my part. But we finally that fall realized that something ought to be done, and we started ABI. So that's, and it, well, the fact is we got, found somebody with the a retired fellow with the Chamber of Commerce of the United States, and he was still living in Washington, D.C. And he said he could write or he could finance or a membership drive for this new organization for if we could raise $5,000. And so we said, okay. And so this fellow that I put in charge put up $1,000. I put up $1,000. My son put up $1,000, and 2 other people put up $1,000. So that was $5,000 that we put up to start this first drive to get some members. And that was in September, October, something like that, of '82. And then in January of '83, we had a meeting in Washington, D.C., in the Senate, some Senate hearing room about this size, a little bigger, and it was full of lawyers all over the United States that we had invited, and the subject was Article 3 or not Article 3. Well, actually, it was different from that. Emergency rule. It was emergency rule, which the Supreme Court had put into effect, or Article 3. And we had, that afternoon, we had testimony from, I don't know, maybe 100 people. Senator DeConcini, the night before, told me he was going to open, he had been appointed by us or solicited by us to be chairman emeritus of the ABI. And so he was interested in that. And so he said, I'll start it off tomorrow, but we want Judge Norton to continue that hearing that day. I said, well, I can't do that. And they said, well, you're the logical one. So they convinced me to preside that day. I now presided from 10 o'clock that morning after DeConcini said he had to go to a meeting where he had to vote. And he never did come back. And we went to 4 that afternoon. I don't even think we had lunch. And hearings, people testifying. And you know, 99% of them were for Article 3 and against the emergency rule. The only people that came testifying for emergency rule was the ad hoc committee of the Judicial Conference of the United States, which were 3, 1 circuit judge and 2 district judges. So that's the way it started.
You have indicated to others, Judge Norton, that serious study should be given to the present core and non-core structure regarding its costs and its constitutionality in an effort to prove the necessity of an Article 3 bankruptcy court. Have you considered asking the ABI or the American College of Bankruptcy to form committees to perform such in-depth studies in order to influence the Supreme Court when it will be faced with the question again?
There are a lot of people around the United States, very thoughtful people, that think that if you had case like Northern Pipeline go to the Supreme Court of the United States, that the Supreme Court would some kind of way finesse it and not rule on the constitutionality of it. So there's a lot of people think that it's fruitless to try to get another case before the Supreme Court of the United States. I'm not one of those. I think that if you know you're right about something, you ought to persist and persist and persist until it happens. I think that we ought to try to have a movement to have articles, and I'm proposing that, and I'm proposing that to ABI, and I'm proposing that to others, that we try to get a lot of people around the United States write articles on the evil of all of the wasteful judicial time that's spent on core and non-core. And you have opinions of various appellate courts and district courts about core and non-core, and it's completely wasteful. And I don't know that the expense of bankruptcy practice is a reason we ought to have Article III courts. I think most people would say that's probably wrong, but I think that that is a evil that we have before us, and I'd like to see a lot of articles on that. I'd like to see a lot of articles also, and we'll present them, we'll publish them in the annual survey of bankruptcy law on Article 3, and I hope that the ABI Journal will also publish them, and then other people around the country publish them. On the question of Article 3, the need and the constitutionality of the present practice of bankruptcy judges. It's my thought that every day of the world, throughout the United States, there are bankruptcy judges ruling on matters that involved the exercise of judicial power of the United States, and therefore those actions are unconstitutional. But nobody's taking an appeal to that, and if you did, chances are a lot of people would say, oh, well, that's okay. But one of these days there'll be some judge like Judge Connolly up there in Minnesota of the Northern Pipeline that'll rule that it's unconstitutional. And maybe there'll be a district judge that'll affirm that and say it's unconstitutional. And maybe it would get to the Court of Appeals, and anyway, I think we ought to try it. So I'm urging editorially and orally as much as I can that we need to get a lot of articles on the present unconstitutionality of the exercise of the judicial power of the United States by bankruptcy judges, and the question of the problems and the expense and wasteful judicial time on the core and non-core.
There's a follow-on.
Following up that question, Judge Norton, are you aware of a difference in the handling of bankruptcy law issues in bankruptcy courts versus Article III courts?
Well, I don't know about aware, because I don't observe. I don't go to court anymore, and I don't function that way. But from what I read, most district judges do not like to rule on and have before them bankruptcy questions. At the same time, and a lot of a lot of district judges would like to be relieved of being one of the appellate courts of bankruptcy issues. But despite the fact that it's an odious responsibility of district judges around the country, a lot of them don't want to give it up either. They don't like it, but they don't want to give it up because it makes them sort of appear like at least what I hear, it makes them appear like an appellate court, and that is image or some of them like. But the circuit courts also, I'm not sure they like bankruptcy cases, because when you read some of the bankruptcy cases that they have, you see them make some errors. I remember back early on, you'd read some opinions of the circuit courts, and they would say, this involves Section 522 of the Bankruptcy Reform Act of 1978. Well, that's not section of the Bankruptcy Reform Act. It's a section of the Bankruptcy Code enacted by the Reform Act. And nowhere they would make, you see a lot of the appellate courts, they still do this. They'll refer to this proceeding before the court. If we deal with this, then this proceeding will be adjudicated and it will be, it'll be terminated. Well, they're talking about a case there. They're not talking about a proceeding, but they use inarticulate, or if that's not the word, wrong terminology about our bankruptcy practice. And I refer you to the interesting the first 3 or 4 pages of the Norton quick reference edition, in which I discuss the various terminologies that are involved in our practice. And I recommend that to you. And I don't want any of you all calling a case a proceeding or a proceeding a case. You all read that and go to court well prepared as to the buzzwords of our bankruptcy practice.
Judge, I have a question for you that is actually a little unrelated. It's off topic. As the mediator examiner in the UNR Industries case, the court has acknowledged your participation in facilitating and executing plan confirmation in what may be considered one of the early mega cases to which we are so accustomed today. What are your thoughts on mediation in bankruptcy today, especially in the mega cases?
Well, you're right that UNR Industries case had been going on 5 years when I was appointed examiner. The judge was a district judge. He might have been a bankruptcy judge then. Appointed me as well. He didn't appoint me. He recommended to be appointed, and I think the U.S. trustee appointed me. But they appointed me in that case with, if you look at the statute as to examiners, definition of examiners, it sounds like it's investigatory, accounting, things like that. Whether there's going to be, has been any wrongdoing about the debtors or people involved with the debtor, things like that. And it doesn't really allude to whether it's mediation or so forth. So he sort of expanded that statute by saying I was going to be appointed examiner, but that he wanted to give the additional authority of the examiner has the authority to, I think he said, moderate, mediate, so forth, the proceeding, and I've forgotten what word he used, but to assist in the preparation of a consensual plan of reorganization. So that was authority for the examiner that no other judge in the United States had thus far imposed upon the examiner, given the examiner that authority. So I was appointed in that case, and I think he appointed me because I was an ex-judge, and then maybe an ex-judge would have some kind of a better influence against the matter than a leading lawyer or some kind of professor or something, which was normally the appointments of examiners. And so I spent 2.5 years more under that case trying to mediate and knock heads, really, of the various participants in that case. If you want to try to mediate normal lawyers and normal professors and so forth, that's almost an easy task compared to trying to mediate a bunch of asbestos lawyers, asbestos claimants lawyers. But we finally did it. Yeah. And I don't think I've answered your question.
Well, do you find that mediation in those
Oh, yeah. I think, by the way, it's become more and more prevalent.
Yes.
Huh?
We have to change
Okay.
To follow up with the mediator examiner question, what are your thoughts in mediation and bankruptcy today?
And I believe that it's now accepted that that can be done. There's been appeals and there's so forth. They've stretched the statute, really, in some people's thinking. But it has been approved, and so I think that it's a device, it's a procedure that has been successful, and I think should be used more and more. The problems of some of these massive cases nowadays is that, see, the judge only knows what he hears from the bench. I mean, from the lawyers out front. Well, a mediator or an examiner can ask questions and have informal meetings with both sides. For instance, I had one meeting with all of the participants, the debtor, the creditors, the secured creditors, and then the asbestos claimant lawyers, and which are billions of dollars of claims of asbestos injuries. And but I never had another meeting of all of them together, except maybe once toward the end. I always met with one side and one side and one side, and I would talk to them. And you see, that takes a lot of trust of the examiner, I think, of them to tell you things, because you can push them, you can cross-examine them, you can, and you learn things. And then finally, though, in my case, there'd been a plan filed early on, and there never had been any hearings, and the case had languished for 5 years because of the asbestos, primarily because of the asbestos case of John Manville, which was filed 3 or 4 months after that case was filed in New York City. So the Manville case was bigger and more popular. But toward the end, when the asbestos claimants would not agree to anything. They would not agree to anything. They wanted the debtor to give in more and more and more. And in that case, as in contrast to the the John Manville case, in that case, one guy or one family owned 55% of the company. So they would go to scorched earth policy rather than give in out of everything. Whereas really the officers and so forth of a lot of these corporations don't own much stock, and so they don't have as much at stake as this. So I knew that they weren't going to give in any more than they'd already given in. But the asbestos people wouldn't give in anything. So they said, "Judge, you got to write the plan." I said, "Well, I can't write the plan." And so finally I agreed. I said, "Well, I'll mediate this thing and I'll propose a plan. But if I propose the plan and the debtor approves it and the secured creditors approve it and so forth approve it, and one of you don't approve it, then I'm going to go to the court and I'm going to tell them who wore the white hats and who's wearing the black hat. And I will tell the judge, and then we'll see." Well, then I went to the judge when I told the judge I was going to file a plan. And I told the judge what I was going to do, that if I got 3 out of the 4, or 4 out of the 5 constituencies that approved it, then I was going to come to the court and I was going to say who held out, and have them explain why. And I was bluffing. I wasn't bluffing really, but I was putting the burden on each of them. Well, we finally did. Everybody agreed except the asbestos claimants. And then we went to the court, and the court said, and I said, Judge, I can't get a consensual plan of reorganization, so I make a motion that I'm allowed to file this plan. Well, you can't do that. You're an examiner. I mean, that's what some of them said. And I said, well, Judge, I think if you read the statute that the examiner can, under these circumstances, file the plan of reorganization. And you know what the judge said? I think so too. Then the other crowd caved in, and we had a consensual plan. So I think that more and more examiners with the authority of mediation is the way of the future. There ought to be more and more of it. These big cases, I don't see how they can get through them without mediation. And they might have mediation on different issues. Mediation on this issue, mediation on this issue, rather than mediation as to the entire plan.
Judge, we have a very important question for you today. As someone who has accomplished so much in your career, do you have any advice for aspiring bankruptcy attorneys such as ourselves?
You mean how to get a job and earn a living? Well, you know, that's a question all graduates of the law schools have, and it's awfully important, of course. One, I advise you, and nobody, you all know what you want. You all know that you want bankruptcy. I guess you do, or you wouldn't be here trying to get this very valuable degree. It's going to be a master's degree, is it not? Well, this is a unique program in the United States law schools, and it's a wonderful program that this school has had imaginative efforts by, I guess, this fellow right here, and I think that's to be commended, that the school has charted this course. And I predict there'll be other law schools around the country in the future that will try to have a master's program also. And so I commend all of you all for being in this course, and the school starting this course. And I commend you on attracting one of America's best lawyers, really. To be the professor of this, that is Professor Lieb, and but well, Professor Warren too, yeah.
And the founder, Professor
Well,
Sidman.
the founder, he's got special accolades, really, to conceive this thing and actually do it. You know, ideas are no good unless you implement them, put them through, establish them. And that's what he's done. That's good. And I guess he's attracted this fellow here, this Professor Warren, and he's has attracted you. Now that's really inspiring to have a leader such as that to bring forth to this school such leaders as you have sitting right over there. That's fine. And to have this program of inviting this old former judge to come up here and be interviewed by this television camera and these top-ranking students has been a very flattering thing to me. That I think that's a wonderful thing that you all are doing, and I hope you will continue this with other people a whole lot better than I am to be interviewed in this fashion. That's good. I commend you. Now I've forgotten what I was going to say, what the question was. But what was your, what?
If you have any suggestions or
All right,
advice
now.
for...
I think one of the best jobs post-law school that anybody can have is to be a law clerk to, in your case, a bankruptcy judge. Now, to be law clerk to a district judge, you see, they have all kinds of things. In fact, 90% of them nowadays are drug cases, criminal drug cases. And who wants to hear those all day? Even including those judges. But bankruptcy judges hear cases of all kinds. I mean, everything is different. Chapter 13 is even good experience. And so I would say that if you could get a job with a bankruptcy judge. Now, there's just, I don't know where you want, you're from North Carolina, I don't know whether you're going back or not to the South. But you see, one thing that I've advised this to other people around the country, and somebody mentions in here Keith Shapiro. Well, Keith Shapiro went to school at Emory, and he was on the law review there, and I became, I had given to the Emory Law School the annual survey of bankruptcy law. We called it annual survey of bankruptcy law of Emory University. And they formed a staff and had a professor advisor like Warner here, and to our law review. But that lasted a few years, and then they started the Emory Development Journal, which is fine. And because I had trouble really dealing with the students anyway, they wouldn't give me do things on time. By the way, back to that earlier, the criticism of Callahan and Company that you couldn't control the people who were contributing editors. I have had no trouble whatsoever in the last whatever the years since 82 in having any of my contributing editors fail to do something that they promised on time. And now we've started seminars in 82 also, and they have to have their materials in at a certain time in order to be published and all that. We've had no trouble at all. My daughter, who's out there y'all met earlier, is supervisor of that, and so she rides herd on the materials that come in for the seminars, and she knows how difficult that is, but we don't have trouble. The people I recruited were great.
So your advice is to work hard and be on time?
That's right.
And
work
to
hard and
pursue
be on time.
excellence?
By the way,
All these
timeliness.
students do that
Timeliness.
all the time.
Timeliness is an attribute of responsibility. If you take on a job and it's got a time, that don't mean that the job has to be done anytime you decide. It means it's got to be done at that time. So timeliness is a part of academics, it's a part of students, it's a part of responsibility. And if you accept something and don't do it on time, you've really failed. I had a law clerk one time that was very bright, very smart, and I've forgotten how I got him, but I would generally tell the law clerk what I was going to rule, and I'd give him the briefs, both sides of the briefs, and the briefs would be marked on, and I would number the findings and facts and conclusions of law. I'd number them 1, 2, 3, and they were supposed to put all that together, and then I would tell them how I was going to rule. And so I had this one fella that he was, by the way, he was a male, not a female. Females I know get on time.
Always.
And so he could never finish something. And what I mean is, he'd bring in and I'd have the draft and so forth, and I'd say, well, this is fine, we'll get it out. I promised it next Friday to the lawyers. And so next Friday would be there, and I said, where's that opinion? And he said, well, I'm still working on it. I got something, I ran across something, I've got to put that in there. I said, I already approved that thing. Anyway, this happened lots of times, and finally I called him in and I said, you're just not working out for me. You got to get another job. I'm going to give you a couple of months to get a job, but we got to have finality to things. Judges are expected to rule, but they also expect to rule on time. And this is true with publishing things. You got to get it to the publisher on time. So he never would do that. So finally, the day he left, he came in and he said, you know, Judge, I'm leaving and I'm going to go back home to so-and-so. And said, but I've enjoyed it here, and I know you are a tough taskmaster, and you are letting me go, but I want to thank you for teaching me one thing. I said, what's that one thing? He says, you have taught me that the way you succeed on things is you become obsessed with whatever that assignment or responsibility is. And you become, I'd never been called obsessed before, but he said, no matter what you do, you get obsessed with this opinion. You got to get out in 3 weeks or 2 weeks, or you get something with this. You got to get it out, and you get obsessed until you get it done. And so I think that's true about a lot of things, that we ought to take responsibility with the intention of getting it done and getting it done on time. Let me say one other thing right here. I read this somewhere one time, that, you know, intelligence about a project, intelligence as to this is very valuable. Dedication to that project is very valuable. Motivation to that project is very valuable. Have I said dedication? Motivation. A lot of things are important, but the most important aspect in human life as to completing something is persistence. That word is more than dedication, and it's more than any other similar word. It means persistence to the end of the project. And so I recommend that too. I want to commend again this school for inviting me up here. It's highly flattering to be somebody come up here. In a way, I wish that Dick Lee would have asked me a year earlier, because last December, all of a sudden, I realized that I was tired. Not tired, but beat. Not beat, but really just exhausted. And normally, throughout my life, I've had a ability of had high energy and drive. But all of a sudden, I hit the wall, it seemed like, and fell off the cliff. And so I went to my doctor, and I told him, I said, I'm just tired, I'm just beat, and so forth. Well, my daddy is too, same age as me. And I said, well, I didn't ask you about your daddy. I want something done by, I'm all of a sudden tired. I thought you got old gradually. I'm already old, but I thought you died gradually. And I said, all of a sudden, I've just hit the wall. So since that time, he sent me about 11 doctors, and various things, all trying to find out. Finally, they found out, Dick, that one reason I was tired, maybe, that in my office, we have 5 or 6 people. They go to lunch about 12 or 12:30, and they come back sometimes at 2:30, and they said, did you go out to lunch? I said, lunch, what's that? I haven't had lunch, and here it is, 2:30, quarter to 3. And I was doing that too regularly. And so now they feed me, they bring me in lunch every day. My daughter over here and my grandchildren that feed me, and so I'm eating good, and now I've got more energy and so forth. But maybe I'll revive and have some energy like I had last summer before December.